And welcome to the Committee for Justice's virtual panel discussion, the antitrust cases against Facebook, examining the lawsuits and implications. My name is Ashley Baker, and I'm your host. I'm the Director of Public Policy at the Committee for Justice, and I'm now going to introduce our panelists briefly in the order in which they're speaking. Stephen Cernak is a partner in the Detroit office of the law boutique of Bona Law PC. He has practiced antitrust law for over 30 years, including more than 20 in-house at General Motors, where he headed up the global competition practice. He is a longtime leader of the ABA Antitrust Law Section and has written for various publications, including the Antitrust Attorney Blog. He teaches antitrust law as an adjunct professor at 2 Michigan law schools. Asheesh Agarwal is Tech Freedom's Deputy General Counsel, where he examines issues of administrative and antitrust law and policy. Asheesh served in senior roles in the administrations of President Trump and President Bush, including at the FTC and the DOJ. At the FTC, Asheesh served as Assistant Director to the Office of Policy Planning, where he helped lead the Commission's competition advocacy program. Asheesh received his JD from the University of Chicago Law School and BA from Northwestern University, which will later this week play for the Big Ten Championship against Ohio State. That's still the case, right? I guess that hasn't happened. Okay. That hasn't happened. I don't know football. Nice. Doug McCullough represents clients in business transactions, international business, and taxation, and has over 20 years of experience doing so. Doug's clients range in size from startups to mid-market and publicly traded corporations. He is also a director of the Lone Star Policy Institute, a free market think tank, and a director of the Canada Texas Chamber of Commerce. Doug is also a National Review Institute Regional Fellow and co-host of the Urbane Cowboys podcast on policy and society. So the brief remarks from our panelists are going to be followed by a discussion, and then a couple of housekeeping notes for Q&A. If all the members of the audience could just send in their questions via the Q&A function at the bottom of your screen. You can do so at any point during the panel, and I will address those with our panelists after our discussion. So let's get started. Steve, the floor is yours.
Thank you very much. And Asheesh, I will say that this week I am a Northwestern Wildcat fan as a 3-time University of Michigan grad. So good luck against that team down south. So we're talking about the FTC, the complaints against Facebook by the FTC and the various states' attorneys general. Both filed in the district court in DC, both of them taking on the same kind of actions. That is saying that Facebook acted anti-competitively in 3 different ways. The first 2 were acquisitions, that is the Instagram and the WhatsApp acquisition. And then the third is first opening up their Facebook platform to connections to that platform to various app developers, and then later on closing down those connections for certain of those app developers. We'll talk more about that, I'm sure. One of the differences is that the FTC makes the claim that all of these actions violate Sherman Act Section 2. That is the monopolization part of the antitrust laws. The state action claims that, yes, all those actions violate Section 2, but also that the 2 acquisitions violate Clayton Act Section 7, the merger-specific part of the antitrust laws. So I want to make 4 points quickly in the time allotted, and then we can talk about them a little bit more as Ashley and the audience likes. First point is something that I wrote for the Washington Legal Foundation a few months ago. Just because you can doesn't mean you should. We've got a pre-merger review system here in the United States and have had since HSR Hart-Scott-Rodino was implemented in 1978. Clayton Act Section 7 allows plaintiffs, including the antitrust enforcers, to invoke an incipiency standard. If the merger may be substantially lessening of competition, a court can block the merger. That was difficult to implement when the parties would merge, close the transaction, and then the enforcers would have to scramble to unscramble the eggs and try to gather the information to first decide if they wanted to unscramble eggs, and then go ahead and try to unwind the transaction. That all changed in the late 70s with Hart-Scott-Rodino. And so for the last 40 plus years, we've had a system whereby the parties file for clearance from the federal antitrust enforcers, and then once they get clearance, then they close the transaction. That process gives the enforcers the opportunity to obtain information, sometimes over the course of months or more than a year, and then make a determination. And that's what happened here. Now, it is clear that even under HSR, that the enforcers like the FTC can go ahead and go after consummated mergers, even ones that they cleared through the antitrust, the HSR process. But it's not the way that things have worked out the last 42 years. And we've had parties, businesses, as well as their financiers get very used to the idea that once you get through the HSR review process, you're home free. You can close and you won't get the antitrust enforcers coming after you. This case will at least damage those expectations, maybe even destroy them. And as a result, maybe we'll get fewer mergers. Maybe those mergers will not be fully implemented. Maybe the parties will be concerned about being too successful going forward as a merged entity, and they won't make the investments that they otherwise would. We'll just have to see what the unintended consequences in merger review will be because of this action. Second point I want to make is on the Sherman Act Section 2, the monopolization claim. Under today's jurisprudence, a plaintiff like the FTC or the states needs to show that Facebook is a monopolist and that they are monopolizing. So they need to prove both the noun and a verb. We're going to spend a lot of time on the verb, and commentators have spent a lot of time on the verb, but I don't think we want to go running past the noun part. Is Facebook a monopolist? That is, do they have monopoly power? Can they act with impunity? Like they don't need to worry about what their competitors do when they change prices or take other actions. Can they, just like rich Uncle Pennybags from the Monopoly game, put their feet up on the desk and just collect $200 every time somebody logs into Facebook? That's really the question that needs to be answered here. Usually, we get at that question indirectly through a static analysis. We define a market, and then we figure out market shares, and if they've got more than 60%, they're a monopolist. That's one way to do it. That's how the complaints do it. That's how we normally do it. But what we're really looking for is, does the defendant here, Facebook, feel like they've got monopoly power? Certainly, they don't seem to be acting that way. And a more dynamic analysis, such as one that's described by Nicholas Petit in his new Maligopoly book, might be the better way to look at it. Even the complaint supports that kind of dynamic analysis. In the market definition section, messaging services are excluded. They're not part of the market. And yet in the monopolization part, what are the bad acts? One of the bad acts was acquiring a messaging service, WhatsApp, because supposedly it was imposing competitive pressure on Facebook. And the complaints list several other potential acquisitions that Facebook has considered recently, all with names redacted, of other companies that supposedly are putting competitive pressure on Facebook. I suspect that Facebook will make those kinds of arguments as well in that claim. Third point, again, Section 2, monopolizing the verb part of it. What will the standard be? The standard would be some consideration of the pro-competitive aspects of these mergers. The complaints list the anti-competitive aspects of it. And remember, the complaints are not saying that these assets were acquired through the mergers, and now those assets are being used in an anti-competitive way. The complaints are saying that the actual acquisitions themselves were anti-competitive, whatever number of years ago. So I think that the plaintiffs will need to go back in time and to see whether essentially the FTC made a mistake, should not have cleared these transactions because the transactions at the time were going to be anti-competitive. they'll certainly be able to use the evidence that's been generated since then, but they'll still need to go back in time in order to take that look. One interesting subset of questions there is whether the Section 7 standard is easier than the Section 2 standard for the plaintiffs to meet. That seems to me to be an obvious answer, that it should be yes. After all, Clayton Act Section 7 was passed because Congress thought that the antitrust laws and the judges interpreting them were not interpreting Section 2 or Section 1 in the right way. That's why Clayton Act Section 7 was passed and then expanded in 1950. And we get the Supreme Court in Brown Shoe in the 1960s saying exactly that. But Professors Tim Wu and Scott Hemphill have come up with an interesting theory based on the Microsoft case, out of the Court of Appeals for DC, that would say the opposite. And certainly we've heard that from FTC officials the last couple of years as well. So that will be, I think, an interesting point that we'll need to pay attention to. And then finally, on the actions regarding the opening up of the Facebook platform to app developers and then closing it down if those app developers are supporting a Facebook rival. It talks about a story of either a refusal to deal or essential facilities. Even monopolists normally have the right to choose who they partner with. It's only in the exceptional cases that the antitrust laws will force them to deal with somebody, especially including their rivals. Lower courts have developed an essential facilities doctrine. So is this facility essential? That could be one of the questions. That doctrine's not been endorsed or rejected by the Supreme Court. What the Supreme Court has said in refusal to deal cases generally, Otter Tail, Aspen Skiing, is that a couple of those exceptional cases when we'll force a monopolist defendant to deal with its rivals are if the monopolist has voluntarily started dealing with those rivals and then stopped dealing with them, and there's no other good reason to stop dealing with them. Also, if the monopolist defendant is dealing with non-rivals, but is choosing not to deal with rivals. So you can see where these claims might fit into those areas. We'll just have to see exactly how this gets fleshed out going forward. So those are my 4 points. Ashley, again, happy to dive into them deeper once we get Asheesh's and Doug's comments.
Thank you. And Asheesh?
Well, Ashley, thank you so much for hosting this. And Steve, thanks for that overview and for the shout out to my alma mater. I'll come back to football at the end of my comments. So I'd like to make 3 comments about the complaint and then maybe put it into a little bit of a historical context. So, the first point I'd like to make is that, I was very surprised that the FTC in this complaint did not mention that it had previously cleared Facebook's purchases of Instagram and WhatsApp. Normally in a litigation context, if you have the bad facts or facts that cut against your narrative, you either try to sort of hide the ball regarding those facts, or get in front of them and provide a narrative. The FTC obviously can't hide from the fact that it did pre-clear these deals, but it doesn't even attempt to provide a narrative as to why it cleared these deals in the first place. I would have expected the FTC to say something like, well, gosh, when we cleared these deals, we didn't have these facts available to us, or Facebook misrepresented what it was planning to do with these acquired companies, or even just, hey, we made a mistake and here's why the market has changed so significantly that we need to take this action now. The FTC hasn't done any of those things. And not surprisingly, one of Facebook's main talking points out the gate is, hey, the FTC already cleared these deals. Why are they revisiting history now? Not legally dispositive, but it certainly is part of the color of this lawsuit. The second point is that reading through the complaints, it is obvious without even hearing from Facebook that at the time of these acquisitions, Instagram and WhatsApp were at most marginal competitors to Facebook, and that's probably why the FTC cleared them at the time. Facebook was thinking about getting into mobile photos, wasn't really seriously thinking about getting into mobile messaging. They saw these companies growing. They tried to develop some technology internally unsuccessfully, and decided that the better thing to do was to purchase them and to add to their suite of products that they could offer to consumers. At the time, Instagram and WhatsApp had a few dozen employees. I think one had 16, one had 55. They didn't have revenue or a viable long-term business model. So at the time of the acquisitions, they weren't really competitors in a meaningful sense. I think that gets to the heart of some of what Steve was talking about in this whole kind of nascent acquisition type of theory, and it really would be quite a sea change in antitrust law and enforcement if we go to a model where if acquired companies do happen to grow after an acquisition, that those acquisitions can be challenged and unwound. The third point I wanted to make about the complaint, and again touches on something Steve mentioned, was the third part of the Facebook complaint sets forth an interesting and at least facially plausible theory as to how Facebook had maybe violated the antitrust laws, and it'll be curious to see what Facebook comes back with. So the basic narrative as laid out in the complaints is that Facebook invited these developers to participate and develop software with it, but on conditions that they couldn't develop software that would rival Facebook's underlying product suite, or even work with rivals to Facebook. Now, facially at least, those could be troublesome from a competition standpoint. And I think Facebook will either end up coming back with a narrative that says, hey, that's not what happened, or some sort of narrative explaining why its actions were were in fact pro-competitive. Now, Facebook limited or eliminated those restrictions in 2018. So another question would be, well, even if there was arguably some anti-competitive behavior at some point in time, what sorts of remedies would we be looking at now that those practices have been eliminated? So more to come on that, certainly. I did want to put this into a little bit of historical context. A colleague of mine at Tech Freedom, Andy Young, and I recently prepared a paper that we submitted to the FTC as part of their 6B study on big tech. It really covered the history of nascent acquisitions. And what we found is that these sorts of transactions have been a routine part of American corporate history for more than a century. Acquisitions of small companies provide those smaller companies with financing and resources and infrastructure that allow those small companies to grow. They allow the larger companies to expand their product suite, and they help consumers by bringing more products to more consumers more cheaply. And the one example that I wanted to share with you is John Deere. So when most people think of John Deere, if they do, the first thing that probably comes to mind is a green tractor with a leaping deer. Well, as it turns out, John Deere did not actually develop the John Deere tractor. That was developed by the Waterloo Engine Gas Company in the early 20th century. John Deere, this is around 1915, tried repeatedly to develop a tractor. They all tried all sorts of fuels and all sorts of models. They all flopped in the marketplace. And what they did was they saw a smaller company, Waterloo Engine, that had developed a successful tractor, and they bought it. They bought the company, and they invested heavily in it. They marketed it, devoted a third of their advertising budget to it, and the bet paid off. Output increased, sales increased by about a third, and they ended up investing in that acquired company, and a few years later came out with a new model. Well, in a lot of ways, what John Deere did is pretty similar to what Facebook did with Instagram, which is to say they identified a need in the market. They tried to develop that technology internally. They weren't able to do so, so they purchased a smaller company that had and increased output. From a competitive standpoint, there's a lot of good that comes from that, and we see that sort of pattern play out in multiple industries, automobiles, aviation, and on and on. So there's a sense that, gosh, big tech is brand new. We need new antitrust tools to look at it, but in reality, there's kind of nothing new under the sun. The final point that I wanted to make is to bring this back to football on an important weekend. I'm going to tie this into Michigan, Steve. So I think advocates of this kind of nascent acquisition theory are making what I like to call the Tom Brady fallacy. Now, if you remember Tom Brady, he was at one point in time a backup quarterback for the University of Michigan and a 6th round draft pick by the New England Patriots. Now, you could say that, oh gosh, it was just destined. It was preordained that Tom Brady was going to win 5 Super Bowls and marry Giselle and on and on. But the reality is that if he had been drafted by, say, a less successful franchise, let's just say the Detroit Lions, to pick one at random, would Tom Brady have become achieved the same level of success? Probably not. He needed the infrastructure and brain trust of, it pains me to say this, I'm not a Patriots fan, but you did need that infrastructure and brain trust in order to be able to succeed. I think you could say the same thing about, WhatsApp, Instagram, and others. Thanks, Ashley.
Well, as somebody who used to root to have played Drew Henson rather than Tom Brady at the Big House in Ann Arbor, I get that reference. So yeah.
Okay, Doug.
Well, Ashley, thank you for inviting me to be on the panel. And first off, I want to say I thought that the presentations by Stephen and Asheesh were very good and saved me from really having to add much. I guess from my perspective, where I'm troubled by the lawsuit, and this kind of goes back to what Stephen was getting at about what the power that the FTC has versus what they should do. I'm concerned from sort of what this does to corporations in their ability to make decisions about corporate development, M&A, any type of big capital expenditure. If you have a situation where you go and you get an approval of any kind, and you can just imagine this not only in the antitrust situation, but really across the board in any type of federal approval, any type of an IRS private letter ruling, SEC no action letter, across the board. If you have a situation where the federal government takes a second bite at the apple, the exact same fact pattern, this isn't like some broad change to the tax code or something, but a second bite at the apple on the same set of facts, you really, Stephen's already alluded to this, that you really hamper the ability to make strategic plans, whether that's sort of the classic build or buy. Are you going to go build a new product line, or are you going to acquire some other company? If you're not sure that just because you've laid out all the facts with all the pertinent information that's been requested, and the government gives you an approval, but then you still don't know that a few years down the road they're not going to change their mind, that's troubling from a corporate perspective. You really can't make those long-term plans when you have that type of situation. So I think Stephen's right too, that maybe then you would see sort of almost hybrid acquisitions where sort of like we acquire a company, but we don't fully integrate it until a certain amount of time passes. And that's not going to be efficient. That's not going to lead to more integration and innovation. And so I have a lot of trouble with this whole approach to begin with. The other thing is again, we know that the acquisitions were approved, and whether or not this is the law, what I would expect to see is that if there isn't a showing that there was some information that was withheld or some misrepresentation, that there was some fact pattern after the fact that shows that Facebook was being anti-competitive. And I think this goes back to the API self-preferencing, right? And that fact pattern. But part of the problem there is if there's a showing that that there was some anti-competitive behavior that was actually harmful to consumers with the self-preferencing, I'm not an antitrust lawyer, and I would defer to Stephen on this. What I would expect is, rather than a remedy of divesting those acquisitions, that I would think that you should first be looking for a remedy that's more narrowly tailored to say, well, if the problem is this particular practice, let's have a remedy that curtails that particular practice, rather than all the talk about the divestitures. And I'll just leave it with one other comment that's a little bit more broad. Is this is sort of why I appreciate this idea of the consumer welfare standard, where we have something that we're actually looking for as a standard. Because if we're left with the question of just simply competition, I'm looking through the petition and seeing all the, essentially right now, I think most of what we're looking at are emails, internal emails from the corporate development team about M&A, and even some from Mark Zuckerberg. And what the petition seems to be pointing to as anti-competitive behavior, I'm looking at a lot of these emails. I'm actually seeing competition, not anti-competitive behavior. I'm seeing that Facebook was actually concerned about their competition. They were concerned that they were vulnerable and they were about to fall behind in certain verticals. And so, I guess my point to that is I think that's where we need to maintain that consumer welfare standard, because otherwise it's just sort of a Rorschach test. But with that, I will defer to Ashley.
Thank you, Doug. Thank you, everyone. That was really good. There are two main points I'd like to first kind of follow up on. They're both, I suppose, pretty broad. But my question is, first, point number one, so this does have larger implications for our system of merger review. This goes way beyond, just Facebook. And it seems there's a lot of, in antitrust now, there's way too much emphasis placed on these tech companies, and it will influence industries beyond that. So how does it influence our system of merger review more broadly? Does it move us more into kind of an ex post system? And also, I'd like to touch a bit on just the buy and bury type strategy itself that they're describing. It doesn't sound exactly unique to tech. It doesn't sound historically unique. I think even in the House Judiciary Committee report, it was something like 63 companies or something they've bought over the past 10 years. I don't remember exactly what the number was, but that does not sound like actually statistically that many. And I guess maybe this would be a question for Steve too, is how does this compare to other industries? Is this behavior at all even really that out of the ordinary?
I think, and Asheesh, has a lot of this in his great paper. The idea of it rather than a buy or bury, it's really, as Doug put it, sort of a buy or build. Can we do it? Should we do it ourselves? Those are two different questions. Or has somebody already done it, or has already gotten a start on it? And if so, let's go ahead and do that. Yes, Asheesh was talking about John Deere. I've got the GM background and can go to, whether it's the Fisher Brothers or all of the entities that became part of AC Delco and everything else. That's how General Motors grew for years and years, and that obviously did not make them a monopolist that could never be toppled, as we all know, and even in particular industries, that was true. It used to be that General Motors had a monopoly in locomotives, and that the electromotive division was started with an acquisition of a teeny tiny company in Ohio that General Motors built on because of its great research and development, and came up with the diesel electric locomotive that put the old style locomotive out of business, and generated lots of benefits for consumers as well as plenty of profits for General Motors. So yeah, I don't think that kind of strategy is unique to big tech. And yeah, if that's going to be in and of itself something that is anti-competitive, as compared to, as Doug described, there's some changed circumstances or the way they use those assets going forward. That could put a crimp on deal making.
Yeah, I would comment that I'm being in Texas, I'm familiar with the oil industry, and it's not that unusual to essentially see what you might call corporate venturing, where you have big oil companies that create what might look like a venture capital fund, although it's really not so much a fund as much as it's their venture capital arm, where they are acquiring or investing in small, growing tech companies. They may be clean tech companies. They're trying to be able to incorporate those technologies. So outside of big tech, it's definitely a thing, and corporations are, do this on a regular basis.
I think we should be very wary about changing the antitrust rules or bringing very aggressive antitrust lawsuits that would have the same effect as changing the rules. None of this happens in a vacuum. the United States is not operating in a vacuum here. I think one point that we like to make that really unites people across the political spectrum is concern about foreign competition, in particular China. Look, the Council of Economic Advisors, congressional research studies have pointed out, rightly so, that Chinese state-affiliated companies are investing heavily in new technology companies. Those are direct threats to U.S. Global technological leadership. And I certainly wouldn't advocate at all for a national champion strategy. Look, we should absolutely treat Facebook and Google and all of the rest with the same. We treat them the same under the antitrust laws as we would treat any other industry. But I also wouldn't try to change those laws or bring these novel antitrust cases aren't grounded in the consumer welfare standard, because the effect of that could be to discourage U.S. investment in startups and new technologies that, quite frankly, we need as a nation.
I agree, and I feel like the message that they're sending is kind of, the only way out is not to be acquired, it's to kind of fight these companies and beat them, which is pretty discouraging for a lot of entrepreneurs, I think. So one issue with this suit too is that, it's built on all of these hypotheticals, and it's also assuming that the only reason that they would acquire these companies is because they were potential competitors. Can we talk a little bit about the different reasons why tech companies would acquire other companies? Years ago, you would acquire other companies because they had physical assets or something that was not necessarily data or part of their business model or another service offering. How are things a bit different now?
I don't mind starting in that. I mean, every acquisition I do, you're essentially acquiring something, and that is either technology, it's a customer base, it's a geographical expansion. So reading the lawsuit, I was sort of chuckling when I saw that the FTC almost made it seem conspiratorial that Facebook was concerned about maintaining their user base, expanding their user base, and acquiring technology. That's 80% of all deals. That's just the norm.
Well, that's right. I mean, what's wrong with that? I mean, Facebook saw that mobile was the wave of the future. They were right about that, and they acquired a company that was well ahead of them technologically in that space. Isn't that what we want to happen? A company sees that, hey, there's a need here and there's a demand here. Okay, we just haven't been able to get it done internally. Let's go out and acquire that company, make the investments, and we'll increase output. It seems to me to be a good story. If you look at other industries, so we've talked about John Deere a lot. So they bought Waterloo Engine because John Deere saw that farmers wanted tractors and they weren't able to develop one internally. So they went out and they bought a company that had achieved that, and they grew that company and they expanded output for consumers. What's wrong with that? That seems to me to be the kind of thing that we want our companies to do.
I will say that I agree with you, Doug and Asheesh, that sometimes the hot documents are not quite as hot as the FTC or the states I think they are. But I will say that if I were a lawyer inside Facebook, I think I would go to Mr. Zuckerberg and say, perhaps just pick up the phone a little more often, not quite put everything in an email, or at least not stream of consciousness. But because there's obviously a lot there. I'm sure those were not the only emails that the FTC got a chance to review. So they gave them plenty of ammunition and plenty of stuff to put in the complaint that they will have to deal with.
Yeah,
Doug, I'd be curious. In your, I was going to say, Doug, in your deal history, I mean, is that something that is in the mind sometimes of the acquired companies? Like, gosh, here's a company that really is going to add to our product offerings and help us grow. And oh, by the way, if we don't do this, and if we don't adapt, maybe we'll be supplanted one day. Does that ever happen? And is it wrong for companies to think that way?
No, that's the norm. I think that unless you're talking about some small family-run business where they're just simply thinking of things as pure business succession, that's the norm. I mean, you're always looking for sustainability, you're looking for growth, and everyone knows that if they're not If they're not growing, they're not developing new technology or acquiring new technology, they're going to be, they're going to be on the receiving end. They're going to be either liquidating or they're going to be gobbled up by someone else. So yeah, it's always the norm.
What about these are using surrounding data, for example? It seems that one of the arguments seems to kind of assume that one of the reasons for acquisitions would be to get more information about their consumer base, but this isn't exactly new, is it? And unique to tech companies. Consumer data has always existed for lots of companies for many years.
Yeah, I don't think there's anything magical about the data. I think that the secret sauce is what you do with the data, in the form of an algorithm, but also more than that. And so I don't think there's anything here in these in this complaint that is specifically focused on data, or there certainly shouldn't be. Instead, the allegations seem to be you saw them as potential competitors or maybe actual competitors, and you bought them up, and then you invested in them and made them better than the product that you otherwise had. And as we've already talked about, what's exactly wrong with all of that? The complaint assumes that if the acquisitions had not taken place, that Instagram and WhatsApp would have continued to grow and would have continued to succeed in the areas where they were, but also that they would have then expanded into an area that Facebook was in. Personal social networking is the market that they've defined, that the complaints define, and I don't know, that's a real, it seems like a stretch, at least, and I don't think that anybody quite saw that. Certainly with Instagram in 2012, yes, there are some quotes from a financial analyst about WhatsApp in 2014, perhaps eventually growing into something like that. So no, I don't think that there's something magical about data, and that's not part of this case.
Actually, I think you're exactly right. I mean, data has been around forever, I suppose, and companies have been using data forever. Tim Uris, former chairman of the FTC, my former boss, wrote a great paper about A&P grocery stores. Well, back in the day, A&P grocery stores did a really good job of using consumer data, sales data, to figure out what products sold in what markets, and it used it to adjust its product offerings with what you might call private labels. The same thing, sorts of things that Walmart and Costco does today, Amazon does today as well. And A&P ended up getting hammered by Congress and in antitrust legislation because of its successful business practices. So again, at one level, there's nothing new under the sun.
So before we get to a couple of questions from the audience, Steve, you raised the point of market definition. I think that's something we should all maybe touch on a bit. Does the market definition here, personal social media networking, does that not seem a bit gerrymandered to apply to this case? What do you all make of that?
Yes, I think it is, and I'd love to Doug and Asheesh to weigh in on that as well. I will say though that in a way, the gerrymandered sounding market definitions are often the result of the process that we use in order to determine the market or here monopoly power. And so we go through and we try to find the perfect substitute through the small but significant non-transitory increase in price process, and we often end up with those kinds of odd sounding market definitions, odd to the ear of the people who are actually in the market. And I think you see that here, even in the complaint, where obviously, if Facebook thought they were in and only in a personal social networking market, they would be a lot less concerned about all these other entities that are not in that market. So I think there's more competition out there that is not shown by going through that usual market definition process.
Well, that is an amusing part of the complaint, where the plaintiffs go through and they really try to explain away why it is that LinkedIn and TikTok and Snapchat and all these others aren't perfect substitutes. And they're not perfect substitutes. They're all a little bit different, but they are at bottom all social networks and alternative consumers.
I don't have anything to add to that. I think you're both right.
Sorry about that. So first question from our audience is, what are the speaker's thoughts on implications of the FTC's actions and approach in this case for competition policy internationally, especially government intervention in the European Union?
Well, I'll start off. I mean, it's you know, to the extent that the other enforcement agencies around the globe, you know, have any you know, reluctance to take on these, you know, big tech companies, not because they're American, but because, you know, the U.S. antitrust agencies who have been amongst the leaders are now maybe amongst the leaders in the antitrust agencies around the globe, to the extent that the U.S. has not taken them on. You know, that might give at least some other of those antitrust agencies some pause before taking them on, and also, you know, taking on this in this particular way, that is going back and looking at prior acquisitions that were not opposed at the time. So I think it does give other agencies the freedom to perhaps you know, pursue similar theories against these companies, Facebook, or against other big tech companies, or other companies generally. So you know, I know that a number of commentators have been concerned that we in the U.S. are falling behind the EU. I've always thought it's not a game who files the most lawsuits or who has the most enforcement actions, but you know, who gets it right and who has the strongest economy, perhaps as a result of, or at least partially as a result of, the right antitrust policy. But you know, to the extent that other agencies are, you know, trying to keep up with the Joneses, you know, that this is now they've got another reason to go ahead and take another step.
Well, Steve, I completely agree. I think this lawsuit, you know, probably enables foreign competition agencies to take more aggressive actions against, you know, against big tech. And I think, you know, Europe has been quite open about this, that they're using antitrust law for what we might call protectionist means. They make no bones about the fact they don't like that you know, the biggest, you know, platforms are, you know, so far still, you know, American-based companies, and they'd like to change that, and they're using you know, European competition policy as a mechanism to do that.
Yeah, and just the only thing to add to that is just that, you know, I think you're exactly right calling it protectionist. I think that if we're not, it's going to basically prevent us from having American administration stand up for American tech companies when the EU or other countries crack down on American tech companies, because they're going to see that we have been rather mercurial about the way that we have, you know, gone through antitrust enforcement.
Right. I mean, it's no accident there are no large tech companies really in Europe, or very few at least. And speaking of which, so our next question is about the consumer welfare standard. It says the lawsuits confront a question that has long foreshadowed the push for antitrust enforcement against tech platforms. How do you prove antitrust injury with a product that's offered for free? Is it time to start considering privacy as part of the consumer welfare standard? I know that's a pretty broad question, but what are all of your thoughts on that?
Well, I mean, I think even before this lawsuit, you've had you know, former Chairman Olhausen and others at the FTC talk about privacy as a part of quality, and certainly quality can be part, you know, something, an attribute that is part of considered as part of the consumer welfare standard. I think the question becomes, you know, we need to have, you know, privacy specific regulation, or is it only something that should be, it can be covered under the antitrust laws? So I think you can bring this kind of lawsuit under the consumer welfare standard, and I think, you know, these complaints are consistent with that. We might agree or disagree whether they're appropriate under that standard, but I don't know that they're under a different standard. But I do think that, you know, it sort of emboldens you know, either these agencies or others to perhaps think of even more adventurous theories under which Facebook or other big tech companies can be charged, outside of the consumer welfare standard.
Speaking of adventurous theories and standards, the duty to deal argument and the essential facilities doctrine, we've seen a lot of instances, aside from this, just this suit, which is kind of pushed forward towards a revival of the essential facilities doctrine or cause for such a thing. What can you explain that argument as part of the suit a little bit and just the broader context there?
Sure. I mean, I think the idea under essential facilities is that this monopolist has a facility that is essential to its rivals, and not sharing it with its rivals will harm them in some way. So in the olden days, you would think of it as the owner, one railroad company that owned the only bridge across the Mississippi for some number of miles. So the question is do Facebook's competitors, can they only reach ultimate users through Facebook in some way? And does preventing the app developers from either supporting Facebook competitors or actually being Facebook competitors, does preventing them from fully using Facebook, does that prevent them from reaching customers in some way? Again, that's the theory that's not been approved or rejected by the Supreme Court. So the Supreme Court is the refusal of the deal doctrine under especially Aspen skiing has been a little broader, but also a little narrower. Broader in that the facility doesn't need to be essential, but narrower in the sense that if the monopolist seems to only have a bad anti-competitive reason for not dealing with a particular competitor, then that can be a refusal to deal, an anti-competitive refusal to deal. And that's where Justice Scalia has described Aspen skiing as at or near the outer boundary of Sherman Act Section 2. So that's why a lot of these cases tried to fit within the Aspen skiing template. Was there prior voluntary dealing that's been stopped? Are you dealing with non-rivals now, but not dealing with rivals? That's why I think you see the complaint try to fit within that either one of those two templates, because that's where the law is now. Yes, it appears that others would like to broaden that out, but I think the complaint does a decent job of at least trying to fit within that template. Whether it does, after Facebook gets a chance to explain why it is that it's taking those actions, is a different question.
I think Steve's exactly right, and I'd refer to the Epic versus Apple suit. Apple has its walled garden that is created for its app store, and that makes a lot of people like Epic unhappy. But Apple has a number of pro-competitive reasons for that, whether you buy them or not. Apple will say, well, gosh, we need to maintain the brand of our Apple store. We have all these security and privacy reasons for imposing these restrictions on working with us, but there are real consumer benefits to that. The complaints against Facebook do lay out, as Steve said, a story whereby Facebook was imposing its restrictions for reasons that weren't pro-competitive, that were instead to stifle competition. And we'll just have to see what Facebook comes back with on those.
We have another question. I'm going to direct this one first to Asheesh. And it's, what do you make of the fact that the vote on the FTC complaint was 3-2 with 2 Republicans voting no? And I'm going to add to that question kind of a follow-up is, how might this play out in the next administration?
Well, I think you have Commissioners Wilson and Noah are what you might think of as more traditional, conservatives, both in terms of kind of their overall political philosophy, but also in terms of their approach to antitrust. Chairman Simons, who I worked with when I was at the FTC, is what you might call more of an antitrust practitioner, somebody who wants to develop wants to develop and bring good cases and test the boundaries of antitrust law. So I think you see that a little bit with the makeup of the folks who voted for the complaint. Yeah, it'll be interesting to see what happens as we go into the next administration. You wouldn't I think Chairman Simons has said that he's planning to step down. Maybe even before Inauguration Day, and so you certainly have the prospect of a 2-2 commission, for a while. So it'll be interesting to see how that affects, any settlement talks, for example, that might arise over the next few months.
So what are the next steps for this suit, though? And what kind of arguments can you see Facebook potentially using or successfully using? I mean, it's not like you can invoke the failing firm defense and say, well, this company that doesn't exist anymore now wouldn't have existed anyway. I mean, what exactly is their best strategy, and how do you deal with these sort of hypothetical scenarios they've kind of laid out?
Well, I think first of all, Asheesh referred to this. I get that the initial reaction, outside of the courthouse of the FTC approved these and this is bad, is disingenuous. But it does raise a real policy issue, and we've talked about that, and that's fine. But I do think they got to go beyond that, and I think at the very least, they've got to explain why it is that they are taking the actions they are taking regarding the APIs, the connections. And I think that, frankly, that would be helpful information to get out into the public or outside the courthouse, so that people start understanding why it is that these kinds of restrictions were put in place. And then, yes, they were changed a year and a half ago. But to start explaining that, I think it would also be helpful to start explaining the great investments that they have made in Instagram and WhatsApp. And they've started to do some of that, or at least refer to that. But I think it would be helpful to explain that certainly at the very least, the acquisitions were not just anti-competitive, that they were not just done for a bad buy and bury reason, but that they were done for good reasons. And as a matter of fact, look at the experience that we've had in the intervening time.
I think Steve's exactly right. Certainly by traditional antitrust metrics, price, output, arguably quality, the acquisitions have been very pro-competitive. Certainly Instagram and WhatsApp have taken off if measured by number of users, for example. The monetary price has remained zero. Recognizing that consumers are kind of paying for something in terms of their privacy. That's pretty well known, that you are giving up some privacy when you're using these free services now. I do, as we've talked about, I do think that Facebook is on that third prong going to have to come up with a narrative as to how its actions were pro-competitive, though.
Okay, we have time for one final question. And it is it a factor in the case that Instagram and WhatsApp in particular cannot likely stand on their own without the backing of Facebook and the revenue from Facebook ads? Spinning them off would result in fewer services, and WhatsApp might likely more back for a paid model, move back to a paid model.
I think that can go to whether there's a violation. I think it also goes to whether a divestiture is the appropriate remedy or not. That is, can you really split them apart in some way? And I think that could be handled, through some number of years of transitional services. Certainly, we've seen conflicting reports in the media about how difficult it would be to have one of these, or either one of these, divested. It'll either be amazingly easy or amazingly difficult, depending on who you talk to. But I think that, yes, those factors can be important on both the liability side as well as the remedy side. And I think but assume an answer to a factual question that I just don't know.
I agree that it gets to remedies. And let's, since we're at the end, let's bring this back to Tom Brady. What happens when he is separated from the Patriots? Well, they are flailing, and his new team is at most a marginal playoff team. So, forced divestitures could have really negative consequences.
The only thing I have. Oh, go ahead, Steve.
I don't think we can top that one, actually.
There you go.
So we have about 5 minutes left. Any closing thoughts to wrap this up?
I'll start again. This is just the beginning. In fact, after you asked us to speak, and before we got a chance to speak, we all saw the Texas AG's lawsuit against Google, which kind of sort of brings in Facebook as well. And we'll hear more about what's going on in Europe. There are continuing investigations by attorneys general and either the FTC or Department of Justice here. This investigation of big tech and the potential expansion of antitrust laws with a merger review or monopolization laws is just beginning, and that's just with the laws that we have today and the courts. With the new makeup of Congress, I think that we'll see at least discussion of expansion of antitrust laws, changing of legislation. So, 30 years ago, people asked me, why are you getting into antitrust? It's a dying area. And it only took 30 years, but eventually I was right.
I would just say something that I'm sure, everybody on this call would agree with is, I would just urge, the new administration coming in to, stay within the white lines of the 40-year consensus on antitrust law, which is to, adhere to the consumer welfare standard and, brace enforcement actions on empirical evidence rather than just on theory. I think it was President Johnson's antitrust division that started to chip away at the notion that big is bad, that we should go after big companies just because they're big. Well, I hope we keep that in mind as we examine the conduct of the big companies.
Well, I guess for me, sitting here in Texas, I suspect that I'm going to be spending more time thinking about antitrust, because it looks like that Texas is not only a leader in election lawsuits, but now also taking the lead in antitrust enforcement. So I'm thrilled. Yes,
they even had like a little, I guess, football reference here, playoff video sort of thing. They were taking the lead yesterday. It seemed more appropriate for ESPN or somewhere. Okay, with that, thank you all for coming out today, especially so close to the holidays. And I will have, for anyone who missed part of this presentation, it will be on YouTube later on the Committee for Justice's page, or in the follow-up email that each of you will receive afterwards. I can include a link there as well. So everyone, Merry Christmas, Happy Holidays, and have a great New Year.
Thank you, Ashley.
Thank you, Ashley.